Welcome. Thanks to everyone for joining. This is one of the events of CIL Dialogues, the international law blog of the Center for International Law at the National University of Singapore. As you can see on your screens, I am Dr. Dina Zuvala. I am an associate professor at the ANU College of Law, and I'm also a member of the editorial team of CIL Dialogues. Today, we are addressing perhaps one of the most controversial, doctrinally vexed, and politically urgent questions when it comes to international law: the role of international law when it comes to addressing reparations for colonial harms. As I'm sure you know, which is why you're here, in the past decade or so, we have been witnessing efforts from different parts, both of the global north and of the global south, to demand, to raise the issue of the ongoing effects of colonialism and imperialism on many communities, and to demand reparations. In fact, and I think that's quite interesting, very often, not perhaps always, but very often, those who demand reparations choose to argue that this demand is not simply an ethical or a political demand, but also it is a legal demand. And as we're going, I think, to discuss today, there is some apparent paradoxes here, given, of course, as we know, the role of international law historically in legitimizing some of the harms related to colonialism and imperialism. Because of this and many other important questions, we thought that this is an issue that we want to address as a blog. And for this reason, we have put together what I think is a terrific panel. So I'm going to briefly introduce them before I get into the substance of the discussion tonight. Before I move any forward, I want to also acknowledge that I'm currently in Sydney, which is unceded land of the Gadigal people of the Eora Nation. And I would like to pay respects to their elders, past, present, and to come, and to acknowledge that sovereignty over those lands was never ceded lawfully. Also in Sydney, we are being joined by Professor Anna Philippa Ventoyak, who is the UNESCO Chair in International Law and Cultural Heritage at UTS, at the University of Technology, Sydney. She's the author of International Law, Museums, and the Return of Cultural Objects. So you can see that she has something to say about the topic. And she's also editor of the Oxford Handbook on International Cultural Heritage. In the past, she has been the Fernand Braudel Senior Fellow, the Marie Curie Fellow, and a Jean Monnet Fellow at the Law Department of the European University Institute in Florence, and she has also been a visiting scholar at the Lauterpacht Center for International Law at Cambridge, as well as the Global Law School of NYU. After Anna, we have Dr. Mamadou Ebieh, who is an associate professor of international law at the Grotius Center for International Legal Studies. He joined the faculty in 2016, and between 2018 and 2021, he was legal officer and a special assistant to the president of International Court of Justice, and he returned in 2021 to Leiden. He's a generalist international lawyer and practitioner, and his areas of interest focus on international dispute settlement, especially concerning territorial and maritime boundaries, together with relating natural resources, of course, disputes, international investment law, international humanitarian law, and human rights. Thirdly, we are joined by Karina Thoira, who is a feminist lawyer and writer. She worked for a long time for the Institute for Legal Intervention at the European Centre for Constitutional and Human Rights. She has taught human rights related courses across a wide range of universities in Berlin, and her fields of specialization include feminist and decolonial legal theory, human rights litigation, gender equality, sexualized violence, as well as law and literature. And what makes her a particularly important participant in today's discussion is that she has been working with Nama and Over Herrero representative when it comes to Germany's colonial genocide in what is today's Namibia. Finally, as a commentator, so his role will come towards the end of the discussion, we have the editor-in-chief of CIL Dialogues, Professor Martins Paparinskis. Professor Paparinskis is a generalist public international lawyer, and he has a variety of specialist interests, such as sources of international law, law of treaties, state responsibility, and international investment law. His work has appeared in leading disciplinary journals such as the American Journal of International Law, the European Journal of International Law, and the Modern Law Review. And he's, of course, a newly sat member of the International Law Commission, and yesterday actually elected chair of the drafting committee. So congratulations are in order. Unfortunately, Vitilagi Fianunu could not join us. He was going to talk about the urgent issue of climate change, international law and reparations, but a health issue intervened. She's sending her apologies, and we are hoping actually as a blog to do a focused event on climate change and reparations in the future. So thank you, all of you, for coming. Thanks to our speakers and to our commentator, and thanks to the audience. I want to ask Ben with a very general question, which is, as you know, and as I already alluded to, the debate about reparations is taking off both in international politics, but also in international law. And I would just be very interested to hear a little bit more how both the academic debate, but also struggles in legal practice take place in your field of study. We are hoping to make this a bit dialogical. So whoever feels inclined to answer this question first, please go ahead and do so. I don't want to have a very rigid panel structure, if that makes any sense. So any of our three esteemed guests who might want to get started?
Tina, I'm happy to start because I'm appearing in clockwise, not for any authority otherwise. I acknowledge, as Natina has done, that I am also on Gadigal land, which is unceded, and we know that they are and have been continuously fighting for the right and recognition, and we'll be talking about some of those aspects as well today. I've also got to acknowledge, and I do this increasingly, is that what I will speak about is because of the knowledge of the generosity of colleagues, particularly First Nations colleagues, about their experiences and what needs to be done. I cannot emphasise enough that from the beginning of my research, I was a practitioner. I'm really pleased to see that most of the panel are practitioners. Most of my work now lies in academia now, but has been fostered by what is required on the ground, and that has always been listening to First Nations peoples and scholars and recognising the generosity despite everything that has gone on and still goes on today, both in Australia and worldwide. In relation to what you've said, Natina, I've got to say, and I'm really glad for this panel, my area, as Natina mentioned, is in relation to a restitution of cultural objects, and specifically cultural objects, but we know that this debate also covers human remains. I, in my research, don't cover that because I think that that is a much broader area, and I think we will talk about that around spiritual aspects of it. But it is highly contested, and it's something that is preeminent in relation to Indigenous peoples, particularly also in the Australian context, because of what that meant with colonisation and the racism that that involved in justifications of colonial practices. I'm happy to speak broadly about my research area, but what I would like to emphasise is 2 points before we go into the panel discussion is that the irony for me is that this debate is finally starting in places where were the metropolitan colonial centres. For other parts of the world, this is not a new debate. It has been something that has been going on for decades, if not centuries. And that is an acknowledgement that people always resisted these practices. And when we talk about, we'll talk about temporality shortly, but this idea of that times have lapsed, I think we need to talk about temporality, about resistance and the colouring of responses to these practices. And I think in some ways I'm also resistant to the term colonial because I think that then fixes it in a particular period when we know that a lot of this is still going on. So it's perhaps not just legacy, but it's a continuation of many of the things that have gone on and those relationships. So I'd like to emphasise that idea of, for us in other parts of the world, this is not a new debate. For those communities and peoples that were subjected to it, it is something that has been called on for a long, long period of time. And my concern when it did emerge in Europe more recently is that the concern that it not be framed by the former colonial powers. Yeah.
Thank you very much, Anna. And yes, even the fact that we open our statements with acknowledging the ongoing character of colonialism where we are, I think speaks to the different temporalities. Karina, Mamadou, whoever wants to weigh in after about your specific area or interest of practice of academic reflection and how the debate plays out, please, either of you, both of you.
Perhaps I start with talking a little bit about the legal struggle and also the political struggle that is going on in Namibia, so that Mamadou can add some theoretical thoughts about it, if you want. For about 5 years, I have been working now with the affected communities, with Ovaherero and Nama, and for about 2 years now, very, very closely with Patrick Kauta, who is a Herero himself and who is a Namibian lawyer. And we have been designing a legal intervention for these past 2 years, a broad one. And one of the main parts of this legal intervention is a domestic litigation in front of the Namibian High Court, which I hope, or fingers crossed, will become a historical milestone, because it could be the very first time that a court of a former colony will declare as unlawful a interstate agreement on the reappraisal of colonial crimes that we think is unlawful for several reasons, and we can dive more into that later, because this joint declaration, this interstate agreement that has been negotiated between Germany and Namibia, basically reproduces all of the colonial patterns that you can think of. In their interstate negotiations, they excluded the affected communities, the Ovaherero and Nama, reproducing the exclusion, the colonial initial exclusion. They reproduce the colonial racism by practically saying that Ovaherero and Nama could lawfully be targeted, killed, raped, etc. And we can go more into that also if you want. we complemented the domestic litigation in Namibia by also contacting the United Nations Special Rapporteurs, who started publishing their communication on Monday. So this is totally recent. And we were very happy that they actually share or confirm what the affected communities themselves, and really it is them who lead. That is very important to say. So I'm only here because I am the one who is designed to think about international law, but it is the Oberherero and the Nama who lead. And it is very clear that Patrick Kauta is the lead lawyer in Namibia and for the whole legal intervention as well. But as I said, we're very glad and happy and grateful that the special rapporteurs confirmed what we have been saying. Basically that these interstate negotiations were unlawful because the participation rights have been violated, and that the joint declaration itself, this interstate agreement, contains no adequate reparative measures. And what we want to achieve as well in front of the High Court in Namibia, that this joint declaration needs to be halted. It cannot be further executed, it cannot be signed, and new negotiations have to start from scratch anew. But this time, according to minimal legal standards. And it is for that reason, if I may add that I am very happy that you invited me to be part of that panel, because we are all very, very aware that we will be only able to achieve the aim we have if we manage to raise sufficient public awareness and also voices in legal scholarship in academia that support our views, that support the legal arguments we bring forward, and that support our aim to finally really decolonize international law, but also our mindsets by getting rid of the colonial racism inscribed into both of them. So many thanks for having me here.
Thank you, Karina. And I believe I saw amongst our attendees, Tony Angie, who obviously has taught us all so much about what Karina just taught about the racist underpinnings of international law. Mamadou, if you want to wait in.
So I would say I got interested in the topic because I got interested in territorial sovereignty and how colonial powers established their authority in the Americas, in Asia, and then in the Pacific, and then finally in Africa. And during that review of colonial expansion, I had to deal with slavery, because the doctrine of slavery by nature was one of the arguments that was used in order to justify slavery between 1415 and 1540. So during that time frame. And recently I've been working with Judge Robinson from the International Court of Justice, who has been trying to trigger a discussion around compensation for slavery. And of course, since the debate about the return of cultural objects has now become prominent in Western Europe, I have been following it to a certain extent. I think from my perspective, one of the key discussion that we have, one of the key issue that we have when we discuss this issue is really how do we determine what was law in colonial period, what was lawful and what was unlawful during colonial period. And there I tend to see diametrically opposed strategies. One strategy is to say that colonial, and as you said, Tina, I was actually smiling when you mentioned it because it gave me my introductory words. It's just to say, oh, international law legitimized colonialism and colonial action during colonial period. That is really quite dominant in the literature. And you have another approach, which I tend to subscribe more to, which is that actually even colonial expansion, slavery, the looting of cultural objects was rather either not authorized by international law or in violation of international law. So instead of international law being a legitimizing factor, I see it rather as a condemning factor, and it does provide more room to discuss a little bit in depth about reparation, broadly speaking. And I believe that the root of this disagreement comes from how we establish international law, because actually when you see international lawyers talking about history of international law or international law during historical period, they run into Western books. They go to Grotius, to Victoria, they read a little bit about Westlake, and they come up with a view which was written by people in Western Europe, pretending to talk about the legal regime applying to interactions that were happening somewhere in Africa, in Asia, etc. It's like if today we were writing an international law framework applicable to the people that astronauts will meet surely at some point in Mars, Venus, and other places, and claim that those entities are bound by the rules that we are claiming. So that's really, in my view, a big gap in our way of approaching colonial history. And that's where I believe that we have to look more into colonial practice itself. We have to look at the views of both the local political entities and the colonial powers about the norms that were applicable to their relations. Because when you look at that, you see that no, the legal rules that were actually acknowledged by all the actors were more in favor of local political entities than what we believe. And it makes sense. The first three ships that arrive in America, they can determine what the Indians are. Actually, they are at their mercy. So we look at things from with insight, and we make it as if the Western colonial powers were winning from the outset, when that's actually they started winning late in the 19th century. So I will stop here for an introduction.
Thank you. These are terrific comments. And actually, I think Karina wants to chip in, and please jump in.
If I may, if that's okay for you, Anna, is that okay? Well, yeah, many thanks for what you said, Mamadou, because if you allow me, I could perhaps give a practical example of what this, or how this retrospective Europeization, Eurocentrism in the case of Germany and Namibia looks like. Because, for instance, the German government, in its application of the doctrine of inter-temporal law, says that they determine the laws in force at the time, and they very much focus on the first element. What they say is the following. They say, well, genocide was not a crime back then because it was not codified. Then they continue saying that international laws of war and international humanitarian laws did not apply because they were basically enshrined in treaties, and as Overherero and Nama had no legal personality within the international legal order, they were not able to sign and ratify those treaties that would have given legal protection to their populations. Then they continue, well, we have international customary laws of war and humanitarian laws. But then they continue saying, well, those were only applied, those legal norms only applied in international conflicts. And wow, as it was not an international conflict, because Oberhero and Nama were not by the Europeans, because they themselves had another point of view, and that is exactly what you were saying, Mamadou, but according to the European view, had no legal personality, so those customary international laws don't apply neither. So the famous colonial laws that then applies, they don't even talk about it, because it's apartheid legal system anyways. And then they come to this basic principles of humanity, civilization, right? That even at the beginning of the 20th century, and the scientific service of the German government acknowledges, was, for instance, used in order to say that the genocide committed against the Armenians right at the same time when the genocide and the crimes were committed against the Oberhero and Nama were unlawful. And then the German government argues that according to the vast majority of legal scholars at the beginning of the 20th century, so according to the laws in force at the time, not even those basic principles, not even the very least basic legal protections applied to the Oberhero and Nama, because by the vast majority of legal scholars, according to this retrospective, hegemonic, very racist view, were uncivilized and not civilized nations. So that is the argument of the German government. So what we say, and it is really, what we say then, okay, if we really start by interpreting and applying the first element of the doctrine of intertemporal law, and we really go back to the end of the 19th century, how can you say that a European international law that perhaps has not even become universal at that time, or was just about to become universal, how can you say retrospectively that this had already become universal, together with all of its colonial, racist underlying that comes along with it? So first of all, make sure that you say something, examine the fact that there has been a polycentric legal order at any point of time. So I don't know exactly where it ended or how it was exactly, but you have to examine that. You cannot retrospectively simply act as if European international law has been the universal international law for the last, I don't know how many centuries. First point. Of course, when we try to do that retrospectively, reconstruct other legal orders, of course, we run the risk to retrospectively be culturally, to reproduce a cultural imperialism, because we are used to the European legal norms that we have been taught and which are the most we find in the legal school books, right? Or in the books, the ones that are published. Point taken, but we have to anyways do more legal research and have a look like which kind of legal order really was there, which were the humanitarian laws, the laws of war that applied in the region of Southern Africa before the German colonists arrived. And there's actually, when you dig deep, when you have a look at it, there is quite a lot of letters written by Hendrik Witbooi, written by Oberhereros, by Maharero, for instance, already complaining about the violation of humanitarian laws and laws of war by the Germans when they committed the massacre of Hornkranz, and that was in the 1870s. So there is really a lot of legal research that has to be done. And then something else, when it comes to the basic legal protection that the German government also denies, and says that not even this basic legal protection was granted, even if you only have a look at the European legal scholars that published their works back then. And that goes back to what Mamadou, what you said. If we really have a look at it and don't impose what has perhaps become hegemonic over a longer period of time. If we really have a look at it, we find counter-hegemonic and other writers, and for instance, even Blunchley, he said that there was a basic legal protection for everyone. So if you look at it, you find one after the other, the inconsistencies of the argumentation of the legal government. And in trying to presume that your own legal argumentation is the correct one, by using only those, and I said, Tina, you also said it in your blog post, the most racist voices that you can find during that time, that is a reproduction of racism. And that is exactly where we're saying to the German government, you cannot do that. You cannot do that in 2023, stand up there and reproduce this kind of colonial racism, because, and that is one of our arguments that we want to bring forward, this is against jus cogens. You cannot be so bluntly racist at the beginning of the 21st century. And just one point we also want to establish a little further, or that people think about it. We also think that the second element of the doctrine of intertemporal law needs more legal research, because it could be that it opens the door for a dynamic interpretation, and that is also, I think, worthwhile to do a little bit more research into many things.
Thank you, Karina. And thank you both, Mamadou and Karina, for transitioning us so smoothly to the second question, right? And as Karina implied, that's how I ended up being quite interested in the questions of reparations, right? I have nothing good to say about the standard of civilization in international law. And yet, when I came across the argument that it denied any protection to colonized peoples, I'm like, that's a preposterous argument, right? Even Blunchley, who was many things, but definitely not a pro-colonized voice, was conceding, and I would say the vast majority of authors at the time were conceding that some minimal humanitarian obligations were due, right? And of course, we could say, you know, is that enough? Of course not, but it is enough to make many of these atrocities clearly unlawful based on intertemporality. Anna, I think it's your turn in case you want to add something from your cultural heritage end of the woods. Anna, you are muted.
I'll pick up from what was, sorry. I'll pick up what I was saying before, and also what was being said now about the colonial as if it's past. When we say and acknowledge that Indigenous peoples have not ceded their lands, in the Australian context and in the settler state context, there is no such thing as decolonisation. Yeah, both from a doctrinal point of view, as we know, but also realistically. And in many instances, in most instances, a lot of those policies have escalated despite apologies and so forth. So this idea of decolonisation, particularly in settler states, is not something that is a past issue. The other thing that needs to be emphasised, and picking up on what I just said, is that when we talk about the past, and I think this is something that Karina may have alluded to, is we talk about it, we're judging time as if it's an act, and it was an act that happened in the past. Whereas we know, both in international law, but in most domestic legal systems, where there is an ongoing harm, time continues to run. And it's a shame that our colleague from Tonga is not here, but we know, and I know in relation to cultural objects, because it is such a huge thing in collections in Europe, believe that if they return it, then that's the end of the matter, that it's finished. Whereas if you see this, and this is the CARICOM 10-point plan, it's nested in a broader reparations claim about ongoing harms, whether it be in relation to health, climate, the environment. It is this broader harm. So when we're talking about, and I'm happy to talk about cultural objects, but it is only one manifestation of, it is clearly an egregious one, because they sit and they continue to say the narratives of the past and justify the narratives of the past. but it is an example of a broader harm, and then it's an ongoing harm. So I don't think we can disconnect all of these elements from each other, and I think that also speaks to when we're talking about intertemporality, about that it isn't a harm of the past, it is an ongoing harm. Yeah.
Thank you very much. Mamadou, you launched us into the intertemporality conversation, but do you want nevertheless to add anything also based on what has been said, or?
I think I will add to just one point, which is that the principle of intertemporality has been criticized for all the ills of history. But I really think that we have to have a sound understanding of it. Intertemporality simply means the following. If you want to assess the lawfulness of colonial looting in 1980, you have to look at the rules of international law that existed in 1980. And honestly, it seems to me that the answer is in the question, because you want to look for the rules of international law applicable in 1980 to a certain situation. And so I don't see why this becomes a big issue. But it becomes a big issue because we do not clearly articulate or because we are unhappy with what is said to be the rules in 1880. So in the 19th century, or in the 15th century, or in the 16th century. And therefore we put the blame on intertemporal law. What we rather need to do is to have serious research on the rules of international law applicable during those periods, taking into account what you called a polycentric international legal orders. I'd speak rather of regionalism in international law, because it just makes sense. From a sociological perspective, international law was universal not before 1960. So it's just a basic fact, and only lawyers actually could think about the fact that if Grotius writes something here, it means something for two Indian communities in the 16th century who do not know Grotius, do not know the king of... I just don't understand it, honestly. But that requires a lot of things, and this will allow me to be even more practical. The key problem is that history of international law is underfunded. It is seriously underfunded. I wrote my PhD thesis on the topic, and for that I needed to learn at least 7 languages, all 7 colonial languages, to be able to read. It's as simple as that. To be able to read, I needed to have access to primary sources. So official document in official languages. So in order to, and even then I wasn't complete, because I wasn't traveling in order to try to get the local political perspective. So we need serious research in order to be able to establish what international law was in that period. And the fact that people just run into Bluntschli, to Westlake or Lawrence is a matter of convenience. If you unearth the relevant materials, no one will be able to come and say these kind of silly things that whatever Vittoria wrote in the 15th century about the Indians. It just doesn't make sense. Even in a public debate, it won't stand 2 seconds. So, and then I would like us also not to throw away the intertemporal law principle because of its second aspect. The intertemporal law second aspect doesn't, in the intertemporal law itself, does not tell us how we deal with the remnants of the past and its legacies. It says that situations which have been established in another system of law, for their continuing validity, have to be assessed in the light of the contemporary rules. So the fact that Great Britain had lawfully acquired, let's say, Ghana, does not tell us nowadays what should Great Britain do about this possession. What it should do about this possession depends on the rules that exist today, of our values, of what we believe is tolerable or not in a contemporary society. And that's the fact. So those who want to obviate this discussion throw in simply, oh, but it was lawful then. But think about human remains. I will take the worst scenario, assuming that you lawfully obtain possession of them. Does it make it more acceptable that you can have them in your living room today? That depends on you and your values. The answer to that question depends on you, your values, and the legal system that is applicable today. And I believe that we really have to have these two rules at the same time. And when we do that, I think it becomes easier to deal with both the historical part. So we have a comprehensive understanding of what international law was in historical period. And secondly, we always ask ourselves, is our conduct with respect to historical legacy reflective of our norms and values? Yeah.
Thank you, Mamadou. That's, I think, especially the final point is really crucial. And I think it's again, you're preempting my questions beautifully. My next question is about what do you think is the distinct value, and what do you think are perhaps the drawbacks, if any, of framing the question of reparations as a legal question, right? What do you think, both in practice, but in symbols as well? And I'm very interested to also hear the practitioners' view. What do you think communities gain, and to what extent, if at all, do you think both their argumentation, but also the chances of actually getting reparations are helped or undermined, or both, by choosing to say that this is not simply a moral argument, this is not simply, even though Mamadou says there is nothing simple about a moral argument, but that this is not only, let's put it like this, it's not only a moral argument, it's not only a political argument, but it is also a legal argument under international law. So anyone who wants to take any aspect of the question.
I mean, I think I can say that for all of the Overherero and Nama that I have been talking to, and this is, for instance, also one of the main reasons why Patrick Kauta and Sima Luipert and the Paramount Chief, everyone is pushing for it, is that they are saying that the initial colonial exclusion and the racist treatment is ongoing while the German government continues arguing with those legal arguments as it is doing right now. For that reason, for instance, also in the domestic litigation in front of the Namibian High Court, we argue that there is a provision in the Namibian government asking the Namibian authorities not to reproduce colonial patterns. And by accepting the German arguments on that topic in the joint declaration, they somehow become complices to this colonial racism. So I would say, from their perspective, it is very, very important that the legal recognition is part of the reparations that they aim at. And when it comes to from a pragmatic point of view, I think that the Overherero and the Nama have a long history of this political and social struggle. And it has gone through various phases, even with an inter-parliamentary forum being possible. And then those secret negotiations between the two governments started. And I really do think that law is a powerful legal means that can help to really perhaps, hopefully, halt the joint declaration. But of course, law and the legal avenue is only one mean amongst others, and they have to go hand in hand, because only going in front of some courts will not help you. You also need the political mobilization. So, and let me just add one thing, which is that I think international law can be a powerful tool to overcome the Eurocentrism and the colonial racism inscribed into international law, precisely for what Mamadou said and what also Makau Mutwa in his article about slavery talks about. Like, it is the next step that we have to take to reach consensus that we want to overcome that what we have been talking about. And this consensus, if we reach that consensus, it sounds simple, but basically this is exactly the transformative potential. We can decide how we want, on which basis, on which legal, on which values we want to continue interpreting international law, and whether we want to establish a legal obligation to grant reparations for slavery and for colonialism. So I think there lies a huge potential.
Thank you very much, Karina. Mamadou, Anna, whoever wants to wade in, you're very welcome.
Mamadou, I'll let you go first.
And I go ahead. It seems that I'm very good at transitions.
You start. You should play cricket. Corinne, I'm going to be facetious and say, when I approached, in fact, the book that Natita was referring to was my doctoral research, so it's a long time ago, it's over 20 years ago, and it was deliberately prepared in a way because I had transitioned from as a practitioner in tort law, and being realistic, I know that law by definition is, and we know this, both a operation of power, both in domestic but also in the international sphere, but it is a tool, and it is a very powerful tool that you referred to in relation to that in so many ways. And so that exclusion that we talked about of the Herrera, but also in relation to whole swathes of the globe, in the formulation of contemporary international law as we know it, Mamadou, absolutely, I think that what he's talking about, and I'll talk about that shortly, about the need to look at the history of international law. When I approached my topic was the idea of, let's have a look at, because when we're talking about inter-temporality in my area, because it covers also private international law, because there are private actors involved, it has always been that, it's the statute of limitations has passed, it's all about morality. When if you look at the practice even of the colonial powers, it was being applied inconsistently. Yeah, I mean, it's quite extraordinary. So even if you're looking at those texts that you're talking about, the English language texts, you go back to them and it's quite telling. I mean, our amnesia in relation to international law is quite extraordinary, even within the metropolitan centres. But also what the laws that they themselves formulated in relation to the sacred trust of civilization for the mandates was not being applied. Yeah, so if we're going to even apply that standard, it was not being applied properly. So I think that in itself, with the historical aspect, Mamadou, what I would say is I absolutely agree. I think when I was going back the 2 decades before, there was very limited, especially around the League of Nations, because I think of that period after the end of the Cold War, is that people thought, there's no reason to look at the past. It's just this progressive development of international law, right, in the 1990s. But now we are more circumspect about it. My concern is that a lot of it is, dare I say it, navel glazing. It's very academic rather than looking at the history, because that's what you do as a litigator, right? Is that you need to look at the documentation to find, we call it discovery in the domestic sphere, but you need to look at it for a purpose, and it's there. I mean, it's so wonderful work. I know it's boring for a lot of people, but sometimes it's the most fantastic work when you hit the jackpot as a litigator, and it's often the other party that's in their documentation and so doing that hard yakka is really, sorry for using the colloquial, is really important. What I would say, Karina, is, and this is a challenge to you, and I think when we say about remaking international law, I am probably not as optimistic as you are. I think that by remaking, there has to be significant power shifts. And there are people that are very, very comfortable in many parts of the world that are not willing to give up that comfort. And we know, I suspect that we are all part of that as well, yeah, of that something needs to give in order for that change to happen. And I am not optimistic, given negotiations in many spheres, but also the significant discrepancies in wealth distribution in societies, but across the world, that those for want of a better word, people are not willing to give up that privilege that they have. So, and that is what will need to be done. So we can all pontificate about values and say we subscribe to them. Are we willing to make that sacrifice to have those values realised, that there is equality? Yeah. And I'm probably not as optimistic as others. I wish I was. And that's why we're still in the fight. Yeah, but yeah.
Thank you, Anna. Mamadou, do you have anything? You don't need to. Don't feel everyone has to answer every question.
No, I don't really. I think that on this question, my views are already known. But probably I would say that yes, international law is very much valuable because it is one norm, one social norm among others. And what we need to get to know is, what does exactly that social norm say? And this is where actually academic work, I have been suggesting the AU to have its own history of international law research on the story of colonial crime and the story of slavery. Yes, because so far we don't have any such research which would enlighten us based on, in my view, on primary sources, documents, as Anna was mentioning, on what was going on the continent from the 15th century till the end of the 19th century. But for this, you really need funding. You need to have a team of researchers, and you need a lot of time to provide not just a rosy picture of history, but history in its entire complexity, because then you can deal with real issues, so that are more complex than what we can make them appear. So yeah.
Thank you very much. No, I agree. And I think it is telling that in different ways, all three of you are coming to questions of both study as academics, but also study as a practitioner of the history, right? And the need to have proper institutional and economic support to do that. So I will ask a final question, and then I'll give the floor to Martins, and I'll ask a final question because I'll try to synthesize some of the questions from the audience. And the question is, in a sense, do you think that contemporary international law, so to leave behind the intertemporality issue, is equipped to give appropriate remedies for colonial harms, right? So Alexandra Fowler is asking, what would reparations look like? Bruno Pegorari is asking, the idea that only immediate harm can be compensated for. And Liliana is asking the question, if the non-tripartite of restitution, compensation, and satisfaction is good enough. So I'll give you one final round of answers for that, if you have any thoughts. I know it wasn't part of the questions I sent you, so if you don't have an answer off the top of your head, that's also fine. Is the law of remedies?
Yeah,
yes, please.
Take this one. Yeah, I would say perhaps one thing that we need to think about before answering the question is the International Court of Justice trying to award compensation to Congo for injury that was committed by Uganda in the 2000-2003 war. This is just 20 years ago. But if you go through the materials, you would see how the courts struggle with them. How do you quantify the number of people who were raped between 2000 and 2003? The people who were killed, maimed, the natural resources that were exploited during that period. In fairness, and I was at the court during part of the period when this was being dealt with, I never felt comfortable with this issue approaching legal principle. And at the end of the day, the principle that the court came up with in the judgment is that, okay, there is a distinction to be made between the breach of international law and the standard to prove the breach of international law and the standard to be used in order to determine compensation, because you can't require the same level of certainty as to the scope of the injury, the causality link, and the valuation. So from a historical perspective, this was just 20 years ago. What if we are talking about slavery between the 16th century and the 18th century? Evidentiary issues will become quite problematic. So what I would think we need to do is to adopt again the same approach and to think about reparation in a very creative way. One way for using a reparation, it is first by abiding by historical truth. And that's what hurts me the most, honestly. And here I'm speaking, it hurts me the most when I hear someone saying that, oh, but yes, Indians were slaves by nature, or the agreements that they concluded with Great Britain didn't mean anything. Because it's first ignorance, and it is also just covering history. And that's not okay. We have to engage with history and to say, no, Great Britain believed that it was bound by these agreements that conferred rights of fishing, rights to territory, to the Indians, and those rights have to be respected. And that's already one form of recognizing historical harm. Secondly, and that's something that I really like as far as Australia and New Zealand and probably all the countries where indigenous people exist. We have to admit that it is not to the indigenous people to prove that their rights have survived colonial period. Why? Because first, we know that at the beginning of the interaction, they had rights, for instance, to their territory. It is the colonial power who is claiming that it acquired those rights. Let it prove it. If it is unable to prove that it lawfully acquired a territory, a cultural object, then it is not his. And that's quite clear because at the beginning of the interaction, those objects did not belong to it. And these are real legal tools that you can use in order to proceed. And last food for thought that I would like to give is thinking about when you think about valuation of the injury or valuation for compensation purposes, we always think about valuation in a retrospective way. So the reparation should bring the injured person to the state it was before injury was committed. But there is another way to think about reparation. It is, what did the injury benefit to the person who committed it? Yes, it's possible to think reparation both ways. It might be difficult today to try to assess how much Africa lost in slavery, in colonialism, and exploitation of natural resources. But it's easier to determine what colonial powers benefited from it. Because nowadays it's quite clear that those resources, what I call capital, the original capital of European countries that allowed them to be developed and to invest in their economy, their industry, came from large part from colonial from the colonies. What those countries are looking for today is access to that capital. And we are conditioning it to the law of foreign investment. We are conditioning it to loans. We are conditioning it often to very predatory trade regimes. What we can do if we really want to recognize colonial harm, it's simply to say, okay, the Congo wants to exploit its natural resources. Today, the Congo needs just to be able to establish one company which is able to exploit Congolese cobalt, transform it in the Congo, and sell it across for it to be in our mobile phone and computers and others. Let's give Congo that money, even if it is a loan, not a gift, a loan for Congo to establish its own companies in order to be able to exploit by itself its natural resources. Of course, when I'm saying this, I'm not naive. I understand that the reason why this original capital will not be given to Congo, because everyone is gaining from it. It's cheap. You go, you exploit, you sell it through routes that don't benefit the Congolese people or the Congolese government. But I just want to say, we need creativity in thinking about reparation. We need creativity to thinking about reparation, and law allows it. Law is not a bar. Law allows it, and it's now for us to think about it. Yeah, thank you.
Thank you. Anna Karina, I'll give you a short minute to each of you to maybe add, because then we are already slightly over time. But please, I do want to hear from you before moving to Martin's.
Karina, I suspect that it'd be better if people finish with your comments. So I'll add very quickly to what Mamadou said is in relation to litigation. Most litigation is brought because it requires creativity. If the law was agreed upon, there would be no need for litigation. So this is our role. I think when I talk about privilege, I talk about as lawyers, and we know that it is a privilege in the sense of that not everybody can become a lawyer, and that is deliberately barred, we know. So I think the privilege is that we use that language and the skills that we have in a creative way to address the issues that we've been discussing today, this evening. Yeah.
Karina, do you want to?
Thanks. I can only add that I also believe that reparations is very much about tackling the transgenerational economic, social, and cultural exclusion that has been installed. And it is very much about rethinking and reshaping the ways we want to live together as an international community, and to get rid of try to get rid of those laws that continue exploitation. And I just want to say one word to Anthony Angie, because I owe him so much. I mean, his works, his texts have been the first ones that really made me rethink. So many thanks for that. I owe you a lot of the path I think I have been able to continue and working together with the Overherero and Nama nowadays. So many thanks at this point of time.
Thanks, Corinne. I think you're speaking for many of us at this meeting and more broadly. On that note, and knowing we are 5 minutes over time, I will hand the floor to Martins for some concluding remarks from this discussion.
Well, thank you, Dina, and thank you, Anna Karina, Mamadou. That was absolutely stellar, and I almost felt that if I had not just listened to you for an hour, the best might have been for Karina's words to be the last ones. But let me just say I have jotted down 4 points. And really, when I was preparing for this, I thought that there might be, as it were, postscripts or questions to raise, but they have been covered much more comprehensively and thoroughly than I would have done myself. So the first point, I suppose, is really the idea that there are different debates in different institutional settings. Some are doctrinal, some present arguments before domestic courts or other institutions, other before international courts and other institutions. There are normative debates, there are political debates. I think that the common theme that I heard, that we are sophisticated enough to appreciate that these are not three isolated areas. Sophisticated doctrine builds on normative considerations, and doctrinal arguments will not necessarily be the same in all settings. And of course, different strategies can supplement each other. And I think that really the key thing that came through, I think, through all three speakers, not to concede doctrine to the opponent, not to, as it were, depart to solely the extremely important normative and political debate, as it were, leaving the law book to the opponent. That is also something that is up for grabs and challenge, and that I think is the key point that I would take away from this. I think that there were a lot of very interesting things about methodology, and when I was thinking, of course, we are struggling slightly when thinking about pre-20th century, particularly things that we think and speak through international law language that has been set down throughout the 20th century, partly still during the time of colonization, but partly from the 1960s onwards on treaties and responsibility and customary law. And I think that there's an important challenge to be thought through both conceptually and I think tactically about the extent to methodological framing of, say, 1969, 2001, or 2018 ask the right questions, which reflects a balance, I think, from many countries, including the decolonized countries, in contributing to the work of the International Law Commission and the Vienna Conference, to contributing to codificatory statements, which could and often have been, in that extent, also applied to historical propositions. So I think we should not assume that people who were contributing to intertemporal law were not conscious of implications that were being made. What I have seen from third country international lawyers, they are extraordinarily sophisticated international lawyers, and certainly it is not, we should not assume that that is something that did not go into a very hard calculation. I think, again, we are on the same page that we should not trust everybody on what they say about small print, even if they ask good questions about the broader methodology. I mean, again, in international law, we are very familiar with that. There are many philosophers who write about international law and ask good questions, but we are perhaps not entirely persuaded by their answers. And of course, in any setting, if we were to read an analysis that does not engage with universal practice of the sort that Mamadou has set an utterly unattainable standard for, of course, we would not take that at face value. So I think that we should really, in a way, treat Lorimer and Bunchley with the same way how we would do it as peer reviewers for a journal. If primary sources have not been sufficiently engaged with, we send that for additional research. One thing that I was thinking about as well about the balance struck, because often in these foundational things, rights, as it were, are balanced with disadvantages. And that is a cost judgment that is being made, that a certain rule, even if it is advantageous in some contexts, might be advantageous in other. And I was thinking whether revisiting intertemporality might have some disadvantages, as it were, second-order effects. And one possible response, I think, is that actually the framing of state responsibility puts the argument on relatively safe grounds, where the establishment of responsibility falls in part two and is agnostic from the actors who are invoking it. And it may well be that our focus is just on responsibility, and rights and interests of the invoking actors, perhaps even on an erga omnes basis, travel independently. And so we really can quite evade the possible rights and obligations of those who bring the claim with a focus on those who engage responsibility. My third point relates to the technical legal arguments. And I think what we heard from everybody, that there is a great deal that can be said and done. I really heartily commend sort of one point that I think Mamadou alluded to from his own talk in the CIL conference a couple of years ago, of, as it were, taking colonial practices at their own methodological terms. if applied against the law of nature and nations formulated by the states themselves, would certain aspects of slavery breach international law? And Mamadou, I think, concluded that they did. And that is, I think, precisely the type of engagement we have to look for. What are the primary rules? Is there a continuous wrongful act? Is there liability expressed in primary rules rather than secondary rules? Because we have been speaking about state responsibility, but of course there may also be obligations that require reparation. Ultimately, and that I think is where doctrine and politics overlap, if formal colonial powers want, and they are uncertain about what the law was, they can explicitly accept as a lex specialis agreement and judge by standard to which they agree. We go back to Alabama. That is what international law has been familiar with on certain points. If there's fuzziness and uncertainty, contemporary sensibilities can express it as a matter of binding international law. And that leads me to reparation, where I think I'm broadly in agreement with what Mamadou said. I have to say my own intellectual journey has been from perhaps looking at reparation in a slightly more formulaic way to ultimately, more recently, thinking and looking more deeply at the way how ILC looked at it in the 1990s, where it was really mostly a proposition of full reparation, leaving considerable flexibility to be implemented differently and attuned to different values and considerations in different institutional settings. So Inter-American Court of Human Rights is radically different in its approach to remedies from interstate. And of course, also in the decentralized setting, most of international law is not run through institutions. And the armed activities case noted by Mamadou is a great example of flexible and creative approach. And of course, putting it in those terms, that we have to be creative is an argument that nobody could disagree with. I don't think that there would be a great party of saying we shouldn't be creative. So this is one of those things where I think that everybody would be on both of course grounds. As I said, I'm really awed at the richness and sophistication of the discussion, of which I learned a great deal. Back to Dina.
I have nothing to add. Thanks to our three incredible speakers. I think the sensibility you brought, which is a grounding on the rules and a grounding on practice, together, of course, with an ethical commitment and a political commitment to eventuating full decolonization in and through international law, is something very valuable. Thanks to Martins for summarizing, and also I think for moving forward the discussion in many respects. And thanks to the over 50 attendees who have stayed on, even though we have gone 15 minutes over time. It is dinner time in Australia, so I'm going to send us all into the weekend. Thank you so very much for your time, and hopefully there will be more CIL dialogues, reflections on the vast number of issues. I think we opened more questions perhaps than we answered, but such is the topic. Thank you all very much and have a lovely day.